under the comp system, or you can pursue a claim in negligence if there was something that was done that failed to satisfy the requirement of using reasonable care under the circumstances. You know, one of the benefits of the comp system is you don't have to prove negligence.
Right. I mean, that's the trade-off. I mean, the trade-off for the employer is, you know, you carry workers' comp, your employee cannot sue you if they get hurt on the job.
So that's the only element there is you are working, you are a W-2 employee, and you're injured. If you meet those criteria, then you will qualify for comp, but you are not entitled to the same level of compensation that you would under the normal tort negligence scheme. Most importantly, pain and suffering, which are the two primary. Under the comp system, you're entitled to have your medical bills paid for, and you can get what's called indemnity payments to compensate you for any wages that you lose. But those are very structured, and they're regimented, and that's part of that give and take of the comp system. You don't have to prove negligence, but you have more limited damages. And I know I've had personally cases where the employer failed to carry the comp and they would have had immunity from suit, but because they did not carry the comp, I was able to sue them in negligence and get the full measure of damages that individual was entitled to under the circumstances. So it gives you kind of that either or option. Joe, it's something you want to look into. We'd need to know more details about the underlying injury to make sure what would be the best path of recovery from you, because sometimes, you know, this is a case or situation, Les, that we have come up frequently. Someone is injured on a premises and they are under the false belief that just because they, for example, maybe fell and hurt themselves on a property, it's not strict liability vis-a-vis the landowner, or and more specifically, the person that's in control of that property, who is the individual that has responsibility for it. You have to show that they failed to use reasonable care under the circumstances. And if you can establish that, then you have the full remedies that you would be entitled to in any other tort case for your past medical expenses, any future medical expenses that can be determined with reasonable probability, your wages in the past, wages in the future, and then if you are able to, you can then get your pain and suffering in the past and the future as well.
Right. One of the things about, you know, Joe, about your question, and I don't want to get too deep into the what does it mean to be a full-time seasonal, because, you know, we do a lot of things with personal injury. We have represented people that are receiving comp benefits. It's not something that we typically handle in our practice, although we do run across it quite a bit. People get hurt on the job when the negligence that caused their injury was somebody other than their employer or a co-employee. Think, for example, the person driving a company vehicle, doing a delivery local, you know, somebody runs a red light, T-bones them. They can still get workers' compensation benefits for being on the job and being in the course and scope, and get those indemnity benefits for wages and the medical benefits. But there's also that third-party claim against the person that caused the wreck. And, you know, how to use the benefits and you know, what should I do? Should I stay in the comp system? Should I wash out? Those are some questions that if you're injured while on the job and it's due to the negligence of somebody other than your employer or a co-worker, you really need to talk with an attorney about that, because you know, I've
lots
had
of pitfalls.
There is, and you know, comp, you know, part of that give and take that we talk about, one of the gives is that you can stay in the workers' compensation system indefinitely, for the rest of your life. So if you have a very serious injury that requires ongoing medical care, you can, you know, conceivably receive workers' comp benefits, whether it be medications, whatever care is needed for that work-related injury. You can end up getting that for the rest of your life. Now, carriers don't want to pay for the rest of their life, so they offer you a settlement, often called a washout.
And it's important that you coordinate that appropriately, because there can be certain pitfalls there as well with respect to future Medicare benefits, disability benefits. If you don't properly take those into consideration and make sure those interests are protected, you could potentially jeopardize future benefits that you think you're going to be entitled to. So it's important, even if you think the comp carrier is doing everything right and taking care of you, you need to have someone looking at it for you, because I can guarantee you they have someone looking at it on their behalf. And so you want to make sure that you're doing everything correctly, and that you are properly preserving all of your benefits, because if you don't have that information to make the correct decisions, you're not going to do the right thing.
That's right. That's right.
And you know, one of the big things is if you resolve that workers' comp claim, they're going to have a potential claim for subrogation against any third-party claimant. So you want to make sure all of these different resolutions are done in conjunction with someone giving you proper advice, so that you do whatever needs to be done to maximize whatever the recovery is, that you can properly take care of your health and take care of your family.
Right. There
Amen.
it is. There it is. All the problems have been solved, at least with regard to that question.
So
Joe, good luck, man. I hope everything turns out and things aren't that serious for you. You know, you were talking about premise liability cases.
Yes.
You dipped into that a little bit, and having those people that come in and say, well, I fell on their property. You know, why won't they pay for my bills? Or, you know, because like you said, it's not strict liability. But, you know, we've talked a little bit about premise liability cases, and these could be cases against businesses. They could be cases against homeowners. They could be cases against local governments. I mean, it really just depends whoever the owner of the premises is. But, you know, in order for you to establish that type of liability, you know, it's got to be more than just simply the event happened.
Correct. You got to show that under some way, shape, or fashion that they failed to use reasonable care under the circumstances. The most typical examples of those are, you know, we kind of have two different main areas. You have where there's some sort of defective condition on the property. A lot of times you're looking at things that may be building code violations, holes in the holes in the premises somehow, or maybe, you know, a faulty piece of concrete or
uneven
wood,
pavers,
those kinds of things, which are just inherently defective in the premises, and they have existed and they should have known something. It's been around long enough that you have notice of it and you should have taken steps to rectify it. The other big broad category of premise liability cases are those where we have what we call transitory foreign substances, which is a fancy way of saying some sort of food or water or liquid or something
that's not permanently there, but
something else permanently there that gets in there. And in those circumstances, you know, did the landowner create the condition themselves? Because then that creates, you know, if they created it, they created the hazard, they know of it, and they need to take immediate steps to rectify it. Or did a third party create that condition and then it's existed on the property for a long enough time that they knew or should have known about it? You know, in law school, we always talk about the example in the grocery store of the, you know, banana peel that's become brown. So it's been on the ground long enough that it's turned brown. Somebody should have known about it. Somebody should have done something, and they failed to do something. Now somebody slips on the banana peel and they're injured. So those are the kind of situations we're looking at, that the person who is in control of the premises knew or should have known of something, didn't take steps to remedy it, and now you've been harmed. And under those circumstances, you have a claim for negligence against that premises owner. The other circumstance, though, there are some situations where there can be sort of, quote, it's not necessarily strict liability, but certain policies will have what's called medical payments coverage, which is a type of insurance that will pay for injuries solely based off of the fact that they happened on the property. Now that's going to be very, very typically a rather small sum. You know, $1,000 to $2,000 to $5,000 you're looking at, but it's something that needs to be explored at any point in time, because you want to. Anytime we get involved, Les, our first order of business is you know, making sure you're getting the treatment that you need to get taken care of, but then B, making sure that we know of all the different buckets of coverage. Doesn't mean we're able to get all of them, but we need to know what they are so that we can point you in the right direction and make sure that you have the tools that are necessary to get you to the finish line of whatever you might need in order to get that recovery process going.
Finding coverage is typically one of the more difficult things. I mean, you would think that if, you know, in an automobile accident situation, it would be fairly common. Well, if so-and-so hit me, then their insurance ought to compensate me. The only problem with that in the automobile world is that in the state of Florida, bodily injury liability coverage is not required. You know? And we talk about it all the time, and I know I sound like a broken record on this, but the state of Florida is one of, I think, the only state in the country that doesn't require a driver to carry liability coverage if they harm somebody. So it's incumbent upon you, if you are, you know, somebody that if you're unfortunate enough to be involved in a wreck, unless you've purchased uninsured motorist coverage, there's a pretty good chance you're going to get hit by somebody that doesn't have any coverage. And it absolutely breaks my heart when people come in, even with relatively minor injuries. Maybe they're out of work for a few days, but you know, there's a lot of folks that are struggling to make ends meet, living paycheck to paycheck. Being out of work for 2 or 3 days, being without a car for a week can create kind of a domino effect. And you know, there's nothing more frustrating than, you know, you get the person in and you're talking to them and you're finding out what's going on. You look at the crash report and you see those 2 or 3 or 4 specific carriers out there, and you look at it and you're like, this person's not going to have liability coverage. They're not going to have any, and you have to explain to the person.
It's tough.
You know, sorry, there's there's not much we can do because your choices at that time are kind of limited.
Minimal.
Yeah, they really are. And so, again, uninsured motorist coverage, that's coverage that you buy. It does cost a little bit more. However, in terms of insurance coverages go, it is among the cheapest.
Very important.
Cheapest coverage you can get. Look at your policy. Pull out your policy and look at the premiums. The highest premium is going to be for your property damage liability because that's the most common claim. The next highest premium is going to be for your personal injury protection, which is mandated by the state of Florida. That's your $10,000 medical benefit if you're involved in a wreck, whether that's your fault or somebody else's fault. That's how what Florida has done. They've made us a no-fault system where we have to rely on our own insurance versus holding the at-fault party responsible for our medical bills and our lost wages. The only problem with that is that coverage limit was put into place in 1972. And Ted,
a little out of whack at this
I don't know what your thoughts are, but I think medical expenses and wages and inflation, those are a little bit different than they were 51 years ago. I know that because I was born in 1972. So in my lifetime, it has not changed one bit.
Right. Well, let's take our first break now, and we'll hit some of these points when we get back. But remember, those phone lines are open, 850-392-1544. Welcome back to Law Call. Ted Howell and Les McFadder with the law firm of Perry & Young here tonight to answer all of your questions about injuries. Over the break, we had an email question come in from Barbara, if we can put that up on the screen. Barbara asked, our tree roots may have caused damage to a neighbor's property. The roots grew under part of their yard. The neighbor tripped and fell and sustained an injury. What is our liability in this situation? Barbara and the roots of the tree.
Yeah, I mean, my gut tells me I don't think Barbara's got any liability in that situation.
Here's the main problem with respect to for the neighbor trying to impose any sort of liability on Barbara in that situation is the actual, quote, defective condition that he's trying to, I assume, allege here would be the tree roots, which were under his possession.
Under his own property.
On his property.
Right.
She honestly does not have the legal right to go onto that property and to do anything with respect to that roots. And when you're dealing with tree roots, a lot of times we enter into an area that often comes up in premises liability cases of things that are referred to as open and obvious.
Right.
It's something that if you can see it and you can perceive it, and you should, I mean, the law presumes that you're going to pay attention and take care of yourself and not, I mean, if there's a 100 by 100 hole in your yard, which would be humongous, you're not going to just walk in it and fall. You can't just go into an open danger. And many times we don't expect to see roots in a a cleared path, but in a yard, that's something that's not atypical. I mean, we live in Florida. We have a lot of oak trees. We have a lot of other trees. There's a lot of, it's not unusual. So you have to be protective of your own self.
Well, and it's naturally occurring too. I mean, I think the distinction there might be, let's say for example, instead of it being a tree root that was causing the pavers and the uneven concrete, let's say it was a diseased tree that had a dead limb hanging over onto the neighbor's property, and that limb dropped on somebody or maybe on their car. That's a totally different situation, because if the tree is, Barbara, if the tree's on your property and it's diseased and it's showing signs of, this limb may fall or this tree may fall over, you have an obligation, legal obligation, to go and make sure that that doesn't happen.
Right, and when you can see that it's diseased, you see that it's rotting, you see this dead. And that was a question we had that came up very frequently after the hurricane. Some folks wanted to try to hold people liable because the tree on their neighbor's yard or from their neighbor's yard ended up on their roof, but that was not through any act of negligence on the part of that other homeowner. That's what we call an act of God.
That's right.
And no one could prepare and prevent things of that nature. But when you have the opportunity, the ability, and the right to control a situation, such as where there is a dead branch or dead limb, and you don't take appropriate steps, and then that injures someone, you have liability. Or if, for example, you built something on your property that then, because of your failure to act reasonably, somehow goes over onto their property, not a naturally occurring, but something that you artificially build, that's another scenario where you have to be careful and you have to take care of that. Another frequent kind of area that we see between neighbors that comes a lot to our attention are dog bites and dog accidents. And people, I frequently get the question, don't we have, one free bite?
The one bite rule, the one free bite?
And there are states that recognize laws like that, with the rationale being you don't know that your dog's dangerous until it's done it once. Well, our legislature has seen fit to not require that kind of obligation. And if it's in essence, if it's a dog and if you're on the property and you have the right to be there, whether it's in the public or on someone's property and you've been invited, and if that dog either, we have cases where dogs run people over, knock them down, break bones, or bite, it's in essence strict liability under Florida law. And there can be similar liability for other kinds of domesticated animals as well. So just know that, understand that. It's a situation that can become really problematic if you don't know the history of your dogs and you don't know what their tendencies are and things of that nature. So you just have to be careful.
Well, and for people that have dogs, it was always kind of funny to me that, what the statute says that a person has to put up in terms of signage if they have a dog that they can't extinguish liability for what their dog does, but they can limit their liability if they post a sign on their property prominently displayed that says bad dog. Which I always thought was kind of funny, because all the signs in the hardware store say beware of dog, but the statute says the sign is supposed to say bad dog. And if you've got that sign, then you could limit your liability in some cases, but most of the time that's going to be for like a trespasser. Somebody that doesn't have
the right and hasn't been invited on the property.
And the other thing is, even though there is strict liability, if you go in and you see this dog and this dog is snarling, you stick your hand through the fence and the dog bites you, yes, there's strict liability, but at the same time there's also comparative fault on the part of the person that did that.
You somehow provoked the dog or otherwise antagonized
you did something stupid.
Don't do that. But another thing that people frequently come to these situations and they find out that they may or may not have coverage for it, because surprisingly to some people, your homeowner's coverage provides coverage for just about all activities of your life, other than if you are driving a car or in some sort of professional endeavor. Otherwise, or boating or other vehicles of that nature. But most of your general activities, your homeowner's policy will cover you, even if you're walking your dog in the park and it does something. But you have to make sure when you're getting that insurance that you disclose to your agent that you have dogs on your property and that that is being covered, because Many times, if you do not actually put that down on your application, it will be excluded from coverage. And even if it's not excluded from coverage, very frequently they will have very low caps on those. I mean, it's not uncommon to have $25,000 limits.
Yeah, you could have $1 million in liability coverage, and then you find out you got a sub-limit for dog bites of $25,000, and we've seen that before. You know, it's a good point to bring up as we're getting into the holiday season. We just had Thanksgiving, we got Christmas coming up. People like to give dogs and puppies as gifts sometime. If you bring a dog into your family and you own your home, you absolutely need to make sure you contact your agent and say, hey, look, we just got a lab or a golden or whatever. We just got a dog. We want to make sure that we're covered under this. A lot of times it will automatically be in the policy. However, you need to let them know about it, because they can still come up and say, well, we didn't know you had a dog. Had we known, that would have changed our risk. That would have changed your premium. Therefore, that is a misrepresentation on coverage, and therefore we're not going to cover you. So if you do decide to add a furry friend there to the family,
make sure he's an insured.
Make sure he's an insured furry friend. Yeah, otherwise you could be really in some trouble if God forbid something happens, a little kid gets bit, something like that, and next thing you know you're getting sued and you don't have that protection that you thought you had.
Well, we're going to take our final break, but the phone lines are still open, so please be sure to give us a call. Welcome back to Law Call, and before we went to break, Les, we were talking about the fact that if you get an animal, you may need to check your policy. And you made a good point that I wanted to point out. With the Christmas time, sometimes you add things like trampolines and pools and things of that nature. There's all kinds of different little items that could potentially become problematic if you don't properly speak with your agent and make sure that they're disclosed and that you have that coverage on there. So as we go through this holiday season, and anytime you're making any kind of life changes, it's always important to get those policies out. Talk to your agent. I mean, that's what they're there for. Make sure they know what you're doing with it. They're human. They need the information. They're not going to go look at your house and see if you've added these things, and they couldn't do that. So you have to tell them so that they can properly advise you on how to handle it.
And one thing I would tell people also, I mean, going online is good. I mean, it's convenient, but there is no substitute. There is no substitute for a good insurance agent that understands where you live, what you do for a living, who you are, what you like to do. Them having that personal knowledge of you in this community can help place you with the right coverage that can also meet your budget. You just go online and start clicking buttons, and next thing you know, you're like, I got full coverage, and you don't have anything.
And you don't know.
That's right.
And you don't know what you don't know. So it's important to get those things.
I'm sure our local agent friends appreciate the plug.
That's right. Les, you got any shout outs?
I do. I want to give a shout out to Miss Pam. Happy birthday month.
That's right.
We're rolling all the way through
month of Pam.
November, December, all into January. My mom and dad got to see my sister and brother-in-law and nephew came up from Tampa this weekend. Shout out to them. Shout out to Nick and Lauren out on the West End. Jamie and Ed, the most active couple in the neighborhood.
Whoa.
My man Rick at the Marlin. And I got to give one big shout out to Big Mike.
Okay.
Good. Big Mike Norvell.
Yes, good job, Mike. I was there. I enjoyed the first half. Got a little shout out to my cousin Brooke, probably the biggest Gator fan I know. She wanted to make sure we talked about her. Miss Catherine Roberts up in Mariana. My good friend Wade Shapiro in Tallahassee. And the best chef around, G Money Star.
That's right, Chef
Gary,
G.
Yes, we love you, Gary, and well, you know, we'll be back next week. We're going to have, for the first time ever on LawCall, the Ryan Hobbs.
The Ryan Hobbs, talking about employment law.
So it's going to be something
our
very
Tallahassee partner.
Yeah, so make sure you tune in and have all of your questions related to that. But until then, you can get us at the office anytime. Good night.
Good night.